going to be doing regulation of lawyers, professional responsibility. And so this class, the introductory class, is always a soft class, and I can tell you're going to say, oh boy, here we go. But it's important for us to contextualize these rules. Very important. So I might ask you some touchy-feely questions like, why do you want to be a lawyer? What do you think about these rules? Did you ever think about these rules while you were practicing in quotation marks over the summer or in your job? And how do you think these rules impact us? So we'll get to that in a minute, but I'm going to go through sort of, as I usually do at the beginning of all of my classes, sort of give you a broad roadmap about what we will be covering in this class. So, of course, it's important for you to take this class because you have to take the NPRE, of course. You have to comply with a particular score, Kentucky Bar Association rules. And so, but we're going to be looking at the model rules of professional responsibility. About 49 states have adopted them in various permutations. And in the real world, in real life, when you start practicing, you're going to look at the Kentucky Supreme Court rules, but which really pretty much follow what we have when we have the model rules of professional responsibility. So there's that. And that's what you'll be tested on the NPRE, just the model rules of professional responsibility, no variations. And our rules are pretty close. The rules that you have in the book are pretty much Delaware rules because the Chief Justice of the Delaware Supreme Court was involved in the early drafting of the model rules of professional responsibility. So pretty much like there's even a footnote in the book that says if you were at Widener School of Law in Delaware, you're actually studying the rules of practice for your jurisdiction. But even though there are different variations on the rules, we are looking at the model rules of professional responsibility. That's what you'll be tested on, both in the NPRE and in this class. The syllabus will be posted after the second class. That's what I usually do, just to sort of see where we're going. And there will be one writing assignment, since we end early and kind of accelerated in terms of our course schedule. But there will be one writing assignment. And why do I say that? I think lawyers write. I think lawyers critically assess. And it's important in this class for you to start that practice of law. So I don't want this book to be dusty on your shelf when you get your first job, or even when you become partner or judge or executive director of the public defender's office. Always refer back. And I'm sort of preaching this, and I didn't do that much in my own practice. So I'm sort of emphasizing some shortcomings I may have had as an attorney. But I was at a large firm, so we had a managing law clerk's office, and so I really didn't look at the rules. I would call down and say, is this okay? But those of you who will be in smaller practices or other contexts, you'll have to be very aware of these rules. So don't take them for granted. That's my point. So I told you to read the preface and the introduction and all that, just to give you a feel for this course. And the preface really defines what we're going to be doing. We have a context. You'll see that this book is different than most of the books that you have in law school. We usually generally focus on appellate decisions. I mean, you might get some trial decisions, but they're sort of in the footnotes. But the majority of what we do in law school is appellate opinions. Now, there will be some appellate opinions in this book, but they're edited so that we get right to the point, and it's more a context for us to apply the rules. So this is going to be a problem-based course. Most of the cases, problems in the book, I think there are about 40 of them. We'll cover a good deal of them. Most of the problems in the book come from real life. And this course is somewhat frustrating because you want the right answer. And sometimes there's ambiguity. And so one thing I want you to leave this course with is the ability to critically assess. Now, you may not get the right answer, but I want you to be able to ask the right question and then try and resolve it that way. There are a number of different techniques. Within your firm, within your practice, talk to people. Reach out to the ethics committee. They can do sort of, quote, advisory opinions. Not binding, but can give you some guidance. Talk to all the right people. And don't think that just because this is the right thing to do, that's what you're going to do. So for example, we're going to be doing something on confidences. That's rule 1.6. And no, you don't have to know the rule numbers. If you've been saying the same thing for over 20 years, you just remember. But we're going to be doing something on confidences. And you know, the impulse is maybe I should tell. My client comes to me. I'm a criminal defense lawyer. I'm just sitting in my office a Friday afternoon. A client comes to me and says, I have defrauded the entire stock market. The news is going to break probably Monday. I need your help. And hundreds of people will be ruined. This is worse than Bernie Madoff. And he tells all of you this. And so what do? Do you pick up the phone and call the Securities and Exchange Commission? This is a rotten guy. He's come to your office for some type of discussion, some type of guidance, relying upon your expertise. And your grandmother has invested in some of these stocks that he's talking about. You know she's going to be ruined on Monday. What do? I pick up the phone and call my grandmother and tell her. Is that all right? Can I do that? Why do you say no? I mean, that's the right thing to do. I want to save my grandmother, and all this money is going to break on Monday. I can get a jump on it, maybe help her. Tell me.
Morally, it may be the right thing to do, but ethically, it isn't. There is a difference between the two.
Yeah, and we have a bad rap for that because the general public, we understand that, right? But that's why we have such a bad reputation as lawyers. I mean, how could you let this happen? Don't you tell. And we're going to see a criminal case in here in a couple of weeks that's just absolutely gut-wrenching. These criminal defense lawyers, and the entire community turns against them. They're hammered. The prosecution is so angry at them that they make up a little small violation just so that they can prosecute them. But we have this responsibility as lawyers to keep these secrets. It's important. And we're going to see one of the chapters that we're going to talk about is the relationship between lawyer and client. There can be no lawyer and client relationship without this bedrock principle of trust, without this bedrock principle of candor between you and your client. Now, so on the other hand, you can't just tell your client what he or she or it, if it's a corporation, you just can't paint a rosy picture. Sometimes in your career, you're going to have to deliver bad news. And it's how you do that. Say you work in the White House and you're working on this political analysis of a trade agreement with China. And your supervisor says, well, I know what the law is. I want you to analyze it. Analyze the law neutrally, but this is kind of the conclusion that we want you to reach. I mean, it could go either way, but I want you to sort of look at the law neutrally, and then the conclusion is, this is the conclusion I want. What would you say in a situation like that? And we're still developing. You don't know all of these rules yet, but what about candor to your client? Would you just go along with that? And then what if your supervisor said, yeah, I want you to analyze the law neutrally. I want you to come out with this conclusion. It's probably not supported by law, but I want you to come to this conclusion. And don't worry about it. I'll sign off on it before you just put your name on it till you sign it along with it. So we're going to see that's another scenario where even as a subordinate attorney, you have responsibilities. So you're not going to be able to say, I want you all to be aware of this. You're not going to be able to say if something bad happens, well, he told me to do it. I'm just out of law school. I'm a subordinate. I work here. I need to keep my job, and that's what I did. So there are responsibilities for subordinate attorneys as well. So that's important. So this book is a problem-based approach, and we're looking at ethical versus strategic considerations, real life dilemmas. where the law, a particular issue might be addressed, how to analyze the relevant rules, and indeed what questions to ask. So this book is structured in this way. You have summaries, they usually come first. They tell us the proposition. Then we have questions and answers and concrete examples and problems. So these are real cases in narrative form. So another question we have to ask, and this is a relatively new course. In the late 70s, this comes out as a result of Watergate. There were 29 lawyers involved in Watergate. 2 attorney generals, the White House counsel, John Dean, he's still around. And so before we would just have this book, they were called canons. And if you just practice law, you would look at these mandatory legal edicts and you would say, okay, I shall not lie to my client. Okay, that's good, check that off. I shall not commingle funds, check that off. And now I'm practicing law. No real critical analysis. And then in the late 70s when we had Watergate, that is when we turned to the systemic study of these rules. So, in terms of the book and how it's structured, we're going to I think we'll be able to do the entire book, and we're going to look at a number of different chapters. So let me go through the chapters, tell you what we're going to be talking about, and then I'm going to take that and talk about the structure of these rules that govern your conduct as law students as well. There's a rule that applies to you even at this moment, and we'll talk about that as well. But in terms of the structure of these rules, we're just going to be looking at, and when we look at chapter 1, we're going to be building upon this notion that we are a profession. We're licensed, we serve others, we have expertise, and we have a defined set of rules and codes that govern our conduct. And so, essentially, when we look at these chapters and weave our way through the rules, we are going to be dealing with a number of issues. Is there violations of the ethical code? Is there some violation of other law? This is another important point I want to make. So it's not just these rules of professional responsibility. You're going to have to always think about context and the rules that govern your conduct. So you have the model rules of professional responsibility. Say you're practicing in the Western District of Kentucky. You have the federal rules of evidence. You have the federal rules of procedure, federal rules of criminal procedure. And then, depending upon the judge that you're in front of, you'll have local rules as well. So you're going to have to keep track of all of those rules. That's not the model rules of professional responsibility. Also, depending on context, you'll have to look at other rules. Say you're doing an administrative hearing. So you'll have those rules as well as the model rules of professional responsibility. Or say you're doing a securities arbitration. You'll have rules there as well that govern your conduct. So there's always this notion of, is there a violation of the ethics code? Is there a violation of other law? And then the point that I just made about calling the grandmother, what is the right thing to do? And you made a key distinction between morality and ethics. So a common mistake that older lawyers used to make was, well, I know the right thing to do, I'll do it, and that will comport with the rules. And we're going to see over and over again that is not necessarily true. You always have to ask, how do the rules operate? So that's sort of what we're doing broadly. And then we're going to go through a number of different things. You'll notice that these chapters are set up in a way that help us define the lawyer in a variety of different roles. So today we're looking at the structure of the legal profession. I'll come back to that. We're looking at lawyer liability in chapter 2. So all of the things that you could do in practice that you could be liable for. The duty to protect confidences. We're going to take a long look at that in chapters 3 and 4, sort of building upon that hypothetical that we just talked about. Lawyer-client relationships, we're going to do in chapter 5. That's important because we're going to take a very close look at how you relate to your client and what that means under the rules. So you have this notion of undivided loyalty, candor. You're an advocate, you're a counselor. And all of those different roles carry with them different responsibilities. So we'll look at that. Then we're going to spend a great deal of time, chapter 6 through chapter 10, on conflicts under the rules. And conflicts are interesting because it impacts the representation. We're asking the question, does the client get the full value of having hired you as an attorney? And so conflicts is going to lead into how we apply these ethical rules. It's going to lead into and reinforce what we talked about in terms of liability. We're going to talk a little bit about disqualification, which is another area that you're going to have to look at because the rules and laws in this particular context are built on a number of different things. We might have some cases. We might have some advisory opinions. We might have some disqualification litigation. So when you're practicing, make sure you check all of those entities. Start with the rule, read the comments, of course, and then build upon that in your research by looking at other things that are related, particularly disqualification cases. Then chapter 11 and 12 will take us broader in terms of our responsibilities and obligations. So just because you represent a client does not mean you can do any and everything you want to advance that client's interest. As an attorney, you also have responsibility to third party. So you can't help your client sort of by lying to the bank and just say, well, I'm representing my client zealously within the bounds of the law. That used to be within the rule, and attorneys were abusing that so much that it was taken out, and now it's simply a reference and a comment. So there are clear boundary lines in terms of representation itself. Those are the duties. And then finally, we'll talk about public service. Now, what's going to drive this class is the integration between what we're reading in the book and our rules, regulation of lawyers. Now, this is important because all of the things that I said about these chapters are formulated in the rules. But let me sort of point out a number of things, and this will sort of bring it home to you. If you look at the preamble to these rules, it sets out the lawyer's responsibility. I'll just sort of highlight some preamble. And I'm not going to, cover the whole rule. I'm just going to sort of highlight, and then you'll see what I'm talking about as we move through the semester. But look at preamble number 1. This is interesting. So these rules really tell you that you're going to have to navigate a number of different roles and then plug them in to how you perform as an attorney. And so you're a member of the legal profession, you're a representative of clients, you're an officer of the system, and you're a public citizen, having special responsibilities for the quality of justice. So you're a member And so the reason this is important is when you have a number of different roles, there are going to be bound to be conflicts. So you like old movies? You know about old movies? Anyway, have you ever seen this movie called Anatomy of a Murder? It was just on. So there's a famous scene in there in the movie where the lawyer meets the client for the first time. And you know as a lawyer you cannot present perjured testimony, right? Can't do that. So what the criminal defense attorney did was he talked about the elements of the criminal offense, and then he sat back and said, now tell me your version of the story. Tell me what happened. Then asked him if he was guilty or innocent. And in fact, that really wasn't an issue, because the whole issue was this guy was an Army colonel, and his wife was allegedly raped by someone. He comes to the house, kills the person, and he says, yeah, I did it, but it was rape. But then there's some incongruities in his story. But the lawyer didn't do that. He just said, tell me your story that, and he didn't even say it, that fits these elements of the defense. And so he sits back and lets the criminal defendant do that. Now notice that isn't telling the client to perjure himself. You're not presenting perjured testimony because you don't know if it's true, and you're not going to examine it any further. You just embrace this client's narrative. Now that's different than a client saying, I'm going to lie on the stand and I want you to put me up there. Or that's different in the civil context of a superior telling you, well, here's the document. I don't know where you're going to file it, but I don't want to see it anymore, and then he leaves the room. So those kind of things and nuances are things that you're going to have to negotiate, and that brings about conflicts. So you're an officer of the legal system. That's important as well. And that's why you cannot present perjured testimony in order to advance the client's interest, because we'll see later, you have a duty of candor to the tribunal. So notice this, another thing, I'm just giving you a broad picture. Another thing you're going to notice is, say you're in federal court and you're arguing in this case, and you notice that opposing counsel, I don't know, maybe through sloppy legal work or maybe not understanding the nuances of the problem, doesn't cite the key case that goes against you. Now, there are a number of approaches you can do in that context. You could say, well, that's not my job. They should have done their work, and that's that. But if this case goes against you and opposing counsel has not cited it, what do you have to do? Do you have to do anything? It goes against you. Do you point it out to the court? Yes. And why? That's going to hurt you, but why would you do that? Yes.
Strategically, you're bringing it up first before opposing counsel, who doesn't even try to bring it up.
All of that's true in terms of strategy and litigation, but what about your duty to the court?
You have to disclose adverse civility.
Okay, yeah. Because you're an officer of the legal system. And notice, in the hierarchy of your obligations and duties, that takes precedent even over your client's interests. So that's why that's important. Another thing, you look at preamble number 2. You're an advisor. You're an advocate. You're a negotiator. You're an evaluator. So notice what the preamble does. It talks about number 1 is more the structural, systemic relationship that you have with the legal system and your clients and how you navigate that. Preamble 2 is more what you do for the client. And preamble 2 talks about all of your responsibilities. Preamble 7. Now notice this. This is what we're talking about in terms of morality. So this is complex. So we know that our conduct and responsibilities are prescribed by the rules of professional conduct, substantive and procedural law. However, notice what it says. It's also guided by personal conscience and the approbation of professional peers. And so we're going to see later on, this is a self-regulated profession, and we rely upon each other to police it. Now, that has come under some criticism because it says, well, that's just like us guarding our own self-interest. who's really going to tell if there's a conflict or something wrong? Who's really going to stand up? And how bad do things have to get before an attorney reports another attorney? But it finally says a lawyer should strive to attain the highest level of skill, improve the legal profession, and exemplify the legal profession's ideal of public service. Important. Now this is a key point. Preamble 9, this is conflict. This is what I've been emphasizing. So even in the nature of practice, you're not going to be able to avoid it. There are going to be conflicts. And notice this, virtually all ethical problems arise from a conflict between the lawyer's responsibility to the clients, in that first preamble, to the legal system, and the lawyer's own self-interest in remaining an ethical person while earning a satisfactory living. So all the things we have to negotiate, our systemic and structural responsibilities to the legal system, our role as an advocate for the client's interests, our own personal self-interest, and preamble 9 tells us when you mix all of those things up, we're bound to have conflicts. So we have a way of resolving these conflicts, and that's what we're going to be doing from chapter 6 to 10. But we'll also see that oftentimes it isn't a clear, concrete answer. Within the framework of these rules, many difficult issues of professional discretion can arise. So we have to be sensitive professionally. We have to understand nuance. We may have to make some moral judgment. But all of those things we do within the context of the rule. Note preamble number 10, self-governance. So the privilege of us having this law license is that we are pretty much free from governmental regulation. We don't want the legislature coming in and telling us what to do. Our high level of expertise means that we can govern ourselves. And so that's what preamble 10 tells us. So notice that's why we look at the Kentucky Supreme Court, delegated authority to the Kentucky Bar Association, integrated bar. You'll be a member of the KBA when you pass the bar. And the Kentucky Supreme Court and the KBA Office of Professional Responsibility is what regulates us, not the Kentucky legislature. And we want this connection. We want ultimate authority over the legal profession vested largely in courts. And the argument goes that we need self-governance so that we can be independent, not overly dominated by the government, and that may undermine our power and authority. That's what footnote 9 says, independence. I'm sorry, preamble 9, independence. So we want our profession to be free from government domination. And so if we have this autonomy, preamble comment 12 says, that means that we have special responsibilities. So there are duties and obligations that arise out of our own independence and self-government. We play a vital role, the preamble says. Lawyers play a vital role preservation of society. So that's the notion of the lawyer as public citizen, advocate, that type of thing. Now, a couple more. 14 is important because it says the rules of professional conduct are rules of reason. So of course, as lawyers, we're going to apply our critical reasoning. And so we're going to see some things that say shall. That's going to be mandatory. We're going to see the word may. That's usually permissive. But, you know, we're going to see contextually that may can mean, yeah, may, but maybe you should. And so that's going to be interesting. So notice an important thing that is spelled out in 14. If a lawyer uses his or her discretion, you can't be punished for exercising that discretion. In other words, if the rule says may and you choose not to do something, you can't come back around and say, oh, that really meant shall. So if a lawyer is acting within the bounds of her discretion, then you cannot be penalized. That's what the rule says. So also this tells us in reading these rules, the rules themselves are the black letter standard that we are held to. The comments help us understand the rules, but the governing principle and rules are set out in the rules themselves. And 16 really sort of tells us what we'll be doing in this course. We're talking about compliance with these rules, of course. So we have to understand the rules. We have to voluntarily comply. There's reinforcement, so knowledge of the rules. Voluntary compliance. And peer reinforcement. So everyone in here, we're not going to let lawyers that we know or that we work with do something wrong. That is a component of self-governance. So we have knowledge and understanding. We're going to comply with what we're supposed to do. Voluntarily comply. That doesn't work. We have peer reinforcement. Don't practice law that way. And then when necessary, we have enforcement. The bar complaint. So another thing that we'll be studying this semester is that these rules certainly provide us guidance and will impact how we practice law, of course. But notice what it says in 16. The rules do not, however, exhaust the moral and ethical considerations that should inform a lawyer. For no worthwhile human activity can be completely defined by legal rules. So not exhaustive, and there are going to be some gaps, and we're going to have to use our critical analysis skills to resolve these issues. The rules simply provide a framework for the ethical practice of law. So, if you look at the rules themselves, they are set up in such a way that we're looking at our relationship with the lawyer, with our client, I'm sorry, and then our relationship with the rules. So we're going to spend a lot of time on Article 1, which is the client-lawyer relationship. And that's no mistake because the lawyer is going to be the agent of the client. Now, we have discretionary power, but the client is going to direct our action. The client is going to tell us what he or she wants. And so under this, we have a number of different things. The first rule in the entire model rules is competence. We have to be competent. Scope of representation. Now that's important because we want the lawyer and client to be on the same page. So the attorney should know exactly what he or she is doing in order on behalf of the client. So the scope of the representation, what the lawyer has to do for the client, is going to determine the parameters of power. Then there are other important things like diligence. Have to work a certain way. Communication, and so on. We're going to look at all of those rules. So that's the lawyer-client relationship. Article 2 talks about the lawyer as counselor. So that's another role that we have as attorneys. So we are primarily an advisor, and it talks about how we have to advise. And the only way that our advice will be worth anything to the client is if the client feels free to communicate everything about the case. Another role in Article 3 is advocate. And I just mentioned, I'm just highlighting some of these. Candor towards the tribunal. That means pointing out adverse authority in a controlling jurisdiction. You just have to do it. And maybe you just talk about that case and distinguish it, that's fine. But you have that duty. Fairness to opposing counsel. Article 4 builds upon that with transactions with persons other than the client. So there's even this duty of trust outside of the attorney-client relationship. Article 5 deals with law firms. Here, pay particular attention to 5.1 and 5.2. 5.1 is supervisory lawyers. So this builds upon self-governance, our independence, our autonomy, making sure that everyone complies with the rules inside of the firm, inside of the organization, inside of whatever entity you work for. The superior, the supervisory lawyer will be in charge of making sure that the rules of professional responsibility are met, but that doesn't alleviate your responsibility as the subordinate lawyer, someone coming into this. You have the same obligations. So it will never do to say, I just signed off on it because he told me to, or she told me 6 is just public service, but it's important. Voluntary public service. So it's not mandatory under the rules, but it is suggested. And there's always been this ongoing debate about, is it proper to mandate that attorneys engage in a certain number of hours? But the argument goes back and forth. We've never gotten mandatory. So it's voluntary under 6.1. And then Article 7 just talks about information about legal services, advertising. And then Article 8 is important. Maintaining the integrity of the profession. Now this is important because we're going to be talking over the semester about a number of violations and a number of different, Article 7 is just advertising. I just took it from the rule, advertising. Article 8 is maintaining the integrity of the profession. Now, 8.4 is very important. It talks about misconduct, and that is sort of this general catch-all that says you cannot undermine the integrity of the profession. So you remember when President Clinton got into trouble, he was disbarred. I think he's been reinstated since then, but he was disbarred for giving erroneous testimony on a deposition. And you notice how that unraveled. The attorney realized that President Clinton had offered false statements. When the attorney realized that, he went to the federal judge and told her. So notice that goes against the client's interest, but your larger interest as officer of the court trumped that. And so then you have the federal judge holding the president in contempt, and then it goes downhill from there. But it's disbarred. But one of the things that was cited was Rule 8.4, misconduct. And we're going to come back to this, but it's professional misconduct for a lawyer to violate or attempt to violate the rules of professional responsibility. So this is sort of a broad category. Or you can commit a criminal act that reflects adversely on the lawyer's honesty or trustworthiness. So we're going to see that catch-all. I want to emphasize, too, under the Kentucky Bar Association rules of the Supreme Court of Kentucky, 8.1, Rule 8.1 applies to you even at this stage, not admitted to the practice of law, but look at this. This talks about bar admission. I'm going to talk about this a little bit towards the end of the class. Bar admission. But keep this in mind when you look at 8.1. So notice, it says, an applicant for admission to the bar shall not knowingly make a false statement of material fact or fail to disclose a fact necessary to correct a misapprehension known by the person to have arisen in the matter. So an omission can be a problem as well. So this, when we go through the bar process and you're starting to assemble your materials, you have to make sure that all of the statements that you are given are true to the best of your knowledge. Now, this rule extends to persons seeking admission to the bar as well as to lawyers. So it would apply to you as applicants to the bar, or if I was applying for reciprocity from one of the jurisdictions I'm admitted in, it would apply to me as well. It also says the rule is subject to the provisions of the Fifth Amendment of the United States Constitution and any state constitutional provision. Now notice this. A person relying on such a provision in response to a question, like if you're invoking the Fifth, should do so openly and not use the right of non-disclosure as a justification for failure to comply with this rule. So that's kind of circular. It's like, yeah, you can assert it, but we would prefer you not assert it and just be candor and disclose everything. So that's just an example of the one rule that applies to you already. So, one other thing. Some central themes in this book. And we did the notion of right or wrong. But we're also talking about this broader question of ethics. This system or theory of principles that govern our practice. So we're going to see in the book even points this out that often, but not always, the right thing to do in a particular situation would mean that you comply with the rules and do the moral thing. But you cannot simply ask the question, am I doing the right thing? It's much more than that. We have to look at the rules. So, there's a number of central themes in this book. For example, if the attorney has a duty of undivided loyalty to the client, then this notion of conflict of interest becomes very important. Because if you have a conflict, you will not be able to adequately represent your client. And we're going to see that a sure sign that there's a conflict is that you can't consider all of the options that are available to you to advance the client's interest. So say, and you really shouldn't do this, but the rules permit you to on some level, and we're going to talk about this in relation to conflicts. Say you enter into a business relationship with a person who's also your client. And there's a rule that allows you to do that. There's all of these steps, informed consent, in writing, fair and reasonable terms. All of these things go into it. But generally the rules, and you'll get the sense that it's a bad idea to enter into a business relationship with the client. And why is that? Your own self-interest may undermine what you have to do for the client. There may be a disagreement that is framed by your self-interest that again would displace the client's interest. Or maybe in a criminal case, you are looking to get a new lucrative client, and that lucrative client says, I really don't like you representing this particular person. What are you going to do about it? And leave it at that. Now, maybe you could fully disclose and say, I'm taking on this lucrative client, I need to make money, and tell the client that you already have of all of these things. But then the question would be, yeah, you have informed consent, but is this something that you could do and move forward in a way that advances both clients' interests? And if you're always looking over your shoulder about this lucrative client and not angering that client and not having that client walk away, that's going to impact the representation that you already have. So we're going to be doing some things with informed consent. Just because the client says it's okay, was that conflict really consentable? So one of the central things that we're going to be looking at is conflicts. And we're going to be looking at concurrent conflicts of interest. That's a situation where you're representing a client, representing clients, and they have things that impact the representation. For example, could you represent Pepsi and Coca-Cola at the same time? Now that's a little bit more sophisticated. What if both of them knew about it and they said it's okay, it's just an economic thing, and so long as you don't share any trade secrets, we're fine with it. Could you do it then? Probably. And we're going to see that a lot of these things are going to turn on context. So you have concurrent conflicts, you have conflicts in particular settings, former clients. Now this is going to be interesting when we look at 1.9. So notice we start with the lawyer-client relationship. We go through that. Maybe the relationship ends. We terminate the relationship appropriately. There are no problems there. But then you take on this new client that may undermine the interests of someone you previously represented. What do you do there? And so we're going to see that this notion of undivided loyalty still remains after that attorney-client relationship is over and that person is a former client. So that is going to be a situation where we're going to have to look presently and forwardly as well as backward to see if there are any conflicts. So we're going to be looking at a current client and a former client when we look at former clients. Also, we're going to look at government lawyers. The revolving door. So that's already happening now. You look at Trump administration, people are coming and going. And so if they go back into private practice, that could be an issue. So I was Secretary of Commerce. I leave and I go to Frost Brown Todd. And then I'm working in securities. Does my former government expertise create any conflicts? Now we're going to talk about something called a confidential governmental information. That's a special type of information that I may have gotten as Secretary of Commerce. And then can I take that in the private sector and use that information? That may be a conflict. Maybe undermines the government's interest, gives my client an unfair advantage because I'm trading on something that I did in the public service sector. So we're going to look at the public lawyer going to the private context and the private lawyer going to the public context. Another thing that we're going to look at is truthfulness, and I've sort of been touching on this throughout our discussion, our preliminary discussion. I mentioned 8.3, report misconduct. Eight 8.4 prohibits fraud, dishonesty, deceit, misrepresentation. Another theme in the book, and I've sort of been highlighting that as well, is lawyer's duty to the client I should put and or the system. So there's some discussion here about a client-centered approach, which would sort of be out of whack. If everything you did was for the client, you would ignore all of these other duties and responsibilities that we've been talking about and create even more conflicts. So it has to be a balance, a client-centered approach versus a public-centered approach. And on the other side, that would be too much too. If everything you said is for the public interest, I'm from the for the system, that could lead to a situation where you could sacrifice the client's interest in order to advance your perception of what the greater good is. And you shouldn't do that either. Another theme in this book is, and I pointed this out in the rules, and you see it over and over again, the lawyer's personal and professional interest. Versus fiduciary obligation. So we have not only undivided loyalty to our client, but we also have, because of our special expertise, these unique responsibilities and obligations. So, years ago, the case where the attorneys were pocketing money that they recovered in a class action. So only giving the clients a small portion of what they ultimately were entitled to. And so that's a clear case of a lawyer's personal, financial, economic interests undermine the overarching fiduciary obligation to the client. Another thing is how self-interest is a theme in the regulation of lawyers. So in other words, if you look at a rule, and we'll see this later, like a rule like fees, our own self-interest is reflected in how that rule is drafted. I mean, we have ultimate control about how much money we will charge. Now, of course, there's some things that we'll see later on in the course that we have to look at. Expertise, the amount of time, customary fees within the jurisdiction, all of those things. But in terms of setting the price, we'll see that the lawyer sets the fee and the lawyer has great discretion. So another theme in this book is the lawyer's self-interest. Expressed in the law governing lawyers. And then finally, as we've been talking about, institutional pressures. On ethical judgment. So thus far, we've talked generally about the structure of these rules, the content of the rules, what we'll be talking about during the semester, highlighting some key components of the rules that build upon how the chapters are set up by looking at all of our responsibilities, starting with the client-lawyer relationship and moving forward, and then the major themes: conflicts, truthfulness, multiple duties, institutional pressures. And all of that starts on page 8 of the book. You have that. So let's go look at the overall structure in terms of regulation of lawyers. I said previously that we're really asking several questions, but they're going to come up over and over again in a semester. One is whether the conduct in question violates the ethics rules. We'll be doing that over and over again. Then we're also going to have to keep in mind that whether or not this conduct violates some other rule. And then finally, what is the right thing to do? So, before we go into institutions that regulate lawyers, I'm curious to get a sense from the class, what has been your experience with these rules in the early part of your career in practice? Did you even think about them, or was there anyone in your firm who said, I want you to pay attention to this, or did you just do your assignment and just hope that when you got it back, your supervisor and attorney would say, great job, and you moved on? How did you think about this? Any experience? Yeah, go ahead. I don't know your name yet. Mr.
Morgan.
Mr. Morgan, go ahead.
So I think confidentiality is like the biggest thing.
You don't have to tell me where you worked or anything, because that's perfect. But how did they approach confidentiality? That's interesting.
Well, we always do it's a personal injury firm, and so basically they say, whatever you hear, say, and do, you just can't bring it outside of the office.
Mm-hmm. Do you think that that's regulated well, or how do you know? Or
I think at our firm it is. I know that a couple of my classmates work with us, and I don't agree with that.
Oh, that's good.
About anything.
All right.
But within the firm, we're pretty much able to discuss whatever.
That's right. That's good. That's good. Now, this is interesting too. So let's say you had a question and everybody in the firm was like, I don't know. Could you reach out to someone and still maintain confidentiality within the rules? And then how would you do it?
I mean, if I was going to do it, I just wouldn't use names, and I wouldn't use any specifics.
Yeah.
I would just use very general terms.
Yeah, hypothetical. And the rules allow you to do that. So every now and then I might get a call from a former student that said, well, this isn't really happening. This is a hypothetical. So what would happen under these facts? Or could you give me some guidance? So and people do that with the Bar Association as well, an advisory opinion. So that's fine. Someone else? Yes, go ahead.
Well, this summer actually, my boss turned in two companies to both Kentucky and Indiana Bar Association for unauthorized practice of law.
Oh wow. Okay.
And it was brought to her attention by two of her clients, and so when she was preparing the exhibits to submit, she had me redact all of the names of the clients so that these companies couldn't retaliate against her clients.
Oh wow. So tell me about her decision-making process in terms of the rules. Did she agonize over it, or did she just say, this is what we have to do?
She's been in touch for decades, so she said, this is what we have to do. Not only do I have knowledge that there's unauthorized practice of law going on, it's affecting my clients as well.
That's good. That's good. Anybody else? Yeah.
Timekeeping where I worked was really important. The very specific way you had to do it, and we were told as summer associates that it was more for us for practice, but that when we got to the real world, we had to be very careful about that.
Okay. That's good. I'm sure I'm not that old, but I want to. So tell me how they keep time now. So when I practiced, we had these diaries, the little thing that sit on you, and then you had to put in the time. And then write up what you did, and then you would give it to somebody, and then they would enter it. But I'm sure it's computerized. Now, how do they keep?
What I had was software that any matter that I was working on, it would have a clock running, and I would have to stop and start it, and then I'd have to put in a narrative. And they were, you're not supposed to put in the narrative later, you had to do it right then.
See, in the 80s and 90s, there was a lot of that, doing it later, at the end of the week, you're like, I remember, or it was just really sloppy, or, I'm talking to the professional responsibility class, and I could say, well, I can bill because I'm talking about professional responsibility, and it's connected to my case. That's just sort of outlandish, but it was sloppy that way, so that's interesting. When do you turn the clock on and off?
Pretty much. Unless they said if you're if you're just walking across the hall to get a copy, that's fine. But if you're going to take a 15-minute break, you had to make sure to turn it off.
Right.
And then they were very picky about the way it was worded and the amount of detail you would go into.
See, and all of this changes. In the 80s and 90s, it was pretty sloppy, but as economics became more of a factor in practice, clients are pushing back now. They will say, "What is this?" And so you can't take a 2-hour lunch and say, well, I'm thinking about the case, so I'm going to bill you. Yeah. You're not really working. And so you're laughing, but I've seen some people do that. So that you can't do that. So that's good. I'm glad that's working. Any other? Okay. So That's very good. So back to the book. Now I emphasize this, but I just want to make it clear. Starting on page 20 or something, it sort of talks about how regulation is done. So we have an integrated bar. We had a Kentucky Supreme Court, and we had a KBA under the authority of the Kentucky Supreme Court. We have the Office of Bar Counsel. And so this notion of inherent powers on page 23, that's what we've been talking about. Usually, from your old government class, the legislature legislates, the executive makes sure that the law is effectively executed, and the courts sort of look at legal principles, constitutional statutes, and then apply the law. But in the inherent powers doctrine, the court says that since we are responsible for lawyers that come before us, we determine the rules. That's on page 23. So courts claim authority to regulate lawyers as an aspect of their power to administer the courts. Then there's even something called a negative inherent powers doctrine, where the courts go so far as saying that we have exclusive power, exclusive regulatory power of the courts over lawyers that displaces the legislature. You even have a case there from Kentucky, where the state Supreme Court held that the law violated the state Supreme Court, the state constitution, where you have Kentucky legislature passing a statute that authorized non-lawyers to represent employees in compensation cases. So we have an integrated bar. You see that on page 25. And then we have lawyer disciplinary agencies. Now, this is important. We've been talking about how it's regulated, but another thing that we'll be talking about during the semester is what happens when there's a violation. Now, there's disbarment, which is the ultimate punishment. And, sometimes that can mean a death sentence. Certainly, you never want to be in that situation. But sometimes it means a death sentence, but sometimes it means 5 years. The bar license is suspended, and then you reapply and can be readmitted. So we're going to see disbarment, suspension, or public or private reprimand. The ABA, the book points out, has limited authority. That's why these are model rules. But 49 states have adopted these in some variation. And that's why on the MPRE, we just test on the model rules themselves. Now, on page 28 and 29, this is the point I was making there. Always, when you're practicing or whatever, you have to look at interrelationships. So, if you are in a particular context, you have to know the federal law, or if you're in a state context, know the state law. But there are other laws that may impact your conduct. And on page 28 and 29, the book makes that point, that lawyers are held to the standard, judges, there's a judicial code of conduct. But the question comes, even if we have a self-regulatory profession, do we really aggressively make sure that the rules are followed? And there's mixed reviews on that. Certainly, the most egregious incidents under the rules are reported, but if you reported everything, that would almost slow down the legal process. So what is the balance? And that's what these rules try to do, but there's no way that you can have a rule that encompasses each and every situation. On page 32, it makes the point that that's why we have these model rules. You see a mugshot of the Attorney General of the United States, John Mitchell. So that was a bad period for lawyers and everything, because you had so many lawyers involved. And a common question during Watergate was, why didn't the lawyers stop it? You had John Dean, White House counsel. You have John Mitchell, Attorney General. number of different lawyers, and no one stopped. So it even points out that the events that were at hand shattered public assumptions that lawyers would never be involved in a criminal activity. And so on some level, even though that was 40 years ago, that's where we are now in terms of how we're viewed. Another aspect of regulation the book points out is malpractice insurance. So this is an example of other law. You have these rules that govern our conduct, but if we are insured, you may have insurance companies saying, we want some compliance structure within your firm to make sure you detect any difficulties that may arise. And of course, the insurance company wants to make sure that you're covering risks and that they won't have to pay out. So risk management and loss prevention measures are designed to reduce the likelihood that the firm will be held liable for malpractice. Protects the insurer as well because they don't have to pay out if there are no violations. Now, let's talk about the development of these rules. Now, it's interesting. From the early period, I would say 1908, we had what we call the canons of professional responsibility. So for almost 62 years, 1908 to 1970, we had canons of professional ethics. Now, those rules were somewhat limited because they were just a conglomeration of thou shalt nots, and you just had to follow those, and that was it. And from a practical standpoint, we had problems with that. So from 1970, we did go to the Code of Professional Responsibility. This was a model code. And so it was a hybrid of those ethical canons, and we sort of had 9 canons, and then we had ethical considerations, and then disciplinary rules. So there were 9 canons that were spelled out. Then these ethical considerations were aspirational in quality, and then you had disciplinary rules which impacted attorney behavior. That still wasn't successful, at least in terms of jurisdictions adopting it. New York still has some variation of the Code of Professional Responsibility. In 1977, there was a Kutak Commission named after the chair of the commission. It was this is on page 35, and it's still a major firm, I think in Nebraska, Kutak, Rock and Campbell. Well, anyway, the chair of the committee started working through the rules, and by 1983, we had the ABA House of Delegates adopting the model rules of professional responsibility. And so that's what we're going to be studying. And so the rules are set up in such a way that they're a restatement format. Black letter rules, comments explain and illustrate the meaning and purpose of the rule. They're guidelines for interpretation. But the text of the rule itself is authoritative. That's what we're looking at. You'll see on page 32 also that there is a judicial code of conduct as well. So if you're before a judge and the judge isn't impartial, or the judge is making erratic decisions, or any number of things, there's also a responsibility in the self-governed profession to report judicial misconduct. Now, of course, I know that could be touching. You'll say, well, I have to appear before this judge all the time. And the rules really don't provide any guidance for that, other than if there's a violation, you have to report. So there's some things in the rules that tell you how to act, but then you have to weigh the consequences as well. And that's life. That's life. Now notice on page 37, it says, do the ethics rule explain most of what a lawyer needs to know about its ethical obligations? I want to emphasize that. The answer is no. On some level, this is going to be a starting point for us. So we can't anticipate all of the problems and provide answers. We have some clear requirements and prohibitions, but these are mostly general guidelines. So let me talk finally about admission to practice. So, years and years ago, there was no requirement that you had to go to college, that you had to go to an accredited law school, that you had to pass the MPRE and the bar exam. It was generally a situation where you had apprenticeships. You sit for the law at a office and then learn about the law. But by the early part of the 20th century, we started having mandatory requirements. You see those contemporary bar requirements on page 40. Some states, you see, even added a pro bono requirement. And so there's a tension in terms of the professionalization of the bar. You see that the ABA started pushing for all of these higher requirements. Accreditation from a law school, passing the bar, all of these. But there's a sort of an unsavory and bad history to this too. If you look at footnote 76, some of these rules were adopted, certainly to professionalize the profession, but the impact was exclusion, and the ABA had a bad history about that. And so you have organizations like the National Bar Association being founded in 1920 because African Americans could not belong to the ABA. So that's an example of that. Bar examinations. You'll have the MBE, of course. There's the practice component of that now as well, and the multi-state professional responsibility exam. So as a component of that, and this is why I said that 8.1 applies to you, there is this analysis of character and fitness. So at the end of this year or early next year when you're compiling all your materials, the Associate Dean for Academic Affairs will look at your file and then certify you to sit for the bar. And then that goes to the KBA, and if they have Office of Professional Conduct, if they have any questions, they'll discuss that with you. But the examination of your character is from across campus, so we don't only look at the law school. There's an associate dean for students across campus in the university, and that person is consulted as well. And then ultimately, there's a short letter. The associate dean for academic affairs signs it, and then you're certified to sit for the bar. But what's really sticky about character and fitness is it's really a prediction of future conduct. And it's always been a discussion about how intrusive should we get. You can't really dig into someone's personal life so much that it disrupts their life. That's not a good way to enter into the profession. But on the other hand, we want a full picture of how this person might conduct themselves as a member of a learned profession. Then on page 43, you get into how intrusive some of these questions can be. I mean, if it's really broad, that could be intrusive and burdensome. I mean, one question that isn't intrusive, but it's certainly burdensome, lists every place that you've lived in the last 15 years. I'm just using that as an acronym. So that's interesting. You sort of have to remember where you were and put that in the application. So look at on page 46 to 47, 46 to 48. Before we leave, I wanted to get a sense how are these decisions being made for admissions to the bar? It seems like they're idiosyncratic, but do you see any common themes? Like, for example, how would you compare, this is on page 47, you had a declaration of bankruptcy, and this person was admitted to practice with $109,000 in debt. She was admitted. The Board of Bar Examiner says, we cannot agree that the evidence sufficiently demonstrates financial irresponsibility. So that was an assessment that they made, but they admitted her. But if you look on the next page, this was in Florida. In Ohio, on page 48, much stricter, $170,000 in debt. Admission was denied. Neglected personal financial obligations. How do you explain those two? Yeah, how do you explain those two? What's the difference? Apart, you could say different jurisdictions, but that doesn't totally explain it. Why do you think there are different results there? Almost the same amount of debt, over $100,000. One says, well, we can't really make a determination about financial irresponsibility. And the other one says, yeah, we can make a determination. Florida says admit. Ohio says deny admission. I'm just bringing this up because I think one of your sessions is first years maybe have been financial responsibility, or it's one of the things we have to look at. So what explains this? Yeah.
In the Florida case, she took some kind of action in regards to her finances, and in the other case, she just ignored it for a year.
Yeah.
Didn't do anything.
And we don't have I think that's right. We don't have the full excerpt, but it doesn't seem like Ohio really analyzed the job market or anything. They just assume, well, find a better job. And I don't know if that could be the analysis, but I think you're right. Being more proactive may have helped. Yes?
In Ohio, he also had a lot of credit card debt on top of the student debt.
Okay. So that was more of a pattern than what we had in Florida. That's good. What about, this is a very serious one. The first one where, and this is in D.C., person is admitted even though he pled guilty to manslaughter and was sentenced to serve 54 months to 15 years in prison, admitted to practice. How was that? I mean, beyond nobody's perfect, but what do you think? Yeah, what explains granting admission? Now, all of these are in there to sort of show that the Office of Character and Fitness is looking at, I guess, a snapshot. I guess the fact that he was a jailhouse lawyer, did all of this education work, then went to Antioch Law School, employed by the ACLU's National Prison Project. All of that shows a steady pattern of rehabilitation. So all of that in this chapter of bar admission and the synopsis of these facts just goes to show that these jurisdictions look at different things, but they're looking at conduct over a particular period of time. So if there's something that's bad and it's a long time ago, that will be contextualized as to how the applicant presents now. Finally, on page 51, it says this. So, as I said before, we're going to be looking at everything. So the information that you put on your bar application has to be consistent with the information that you disclose on your law school application. It should be the same. The law school's dean office is asked to fill out a questionnaire on each applicant. I already talked about that, and it contains various questions. And so an omission on your law school application could lead the dean's office to provide information that is inconsistent with the information that you provide. So when you go back over your papers, just make sure, no big deal, you just make sure that your law school application and bar application are harmonious. So when we come back, we're just going to do these two problems that remaining in chapter 1 sort of to start off, and then we're going to finish chapter 2. And that's so we're going to be averaging about 35 to 40 pages because we're on this abbreviated schedule. The syllabus will be posted at the end of our second class. And so we're going to finish up chapter 1 and then complete chapter 2. And then next week that'll set us up to start the substantive work of looking at this rule, starting with protecting confidence. Have a good afternoon.